Which offences can be investigated by the ED?
They can investigate offences under PMLA, Prevention of Money Laundering Act, or under FEMA. So both of these offences would be under the authority of ED. But we must note that there are scheduled offences under PMLA, which makes the ambit of PMLA very wide. So these scheduled offences could be offences under IPC, offences under various several statutes such as customs or wildlife or human rights, human protection, etc. So all of this would possibly be also covered when ED investigates.
Explain the scope of the offences of money laundering under Section 3.
When we were arguing the decriminalization of statutes, specifically also related to PMLA, before the Supreme Court, the moot point before the Supreme Court was that what sort of offences, predicate offences, etc., would fall within the purview of money laundering. And let me try to explain that with an example. The scheduled offence, for instance, may be 302 of the IPC in the PMLA Act. Now, in my example, if A commits murder and kills B and money is not involved, certainly PMLA Act may not come into play. Second situation could be when A kills B and money is involved and that money is also laundered and falls within the purview of Section 3, then certainly PMLA Act will come into play. The moot point which remains is on a situation where A kills B, money is involved, but that money may or may not fall within the purview of Section 3, and whether there is laundering to that effect, and hence whether in that situation PMLA Act will come into play. 2019, the amendment was brought into force to include an explanation, and let's understand what this explanation says. The explanation has been added in 2019 to say that a person shall be guilty of offence of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activities connected with the proceeds of crime. Interestingly, this explanation includes possession, concealment, acquisition, use, projecting as untainted money, or claiming as untainted money in any manner. Now, what happens is, by way of this explanation, while the explanation very clearly provides that possession of this would also be included, so which means that any activity connected with the proceeds of crime, and when there is a possession with respect to that as well, the provisions of Section 3 will kick in. If we see the definition of Section 3 subsequent to the amendment of 2013, it said proceeds of crime including its concealment and possession as well. So the phrase which was used included possession, acquisition or use, and projecting or claiming it as untainted property. So the provisions by way of an explanation make the ambit of Section 3 very wide, which means any possession or use of that proceeds would also get covered, which means that the definition under PMLA becomes very wide. And when these specified acts under the schedule, these scheduled offences are invoked, these could be different acts or offences under the different statutory provisions, but all of this gets covered even under the PMLA Act.
Precautions are necessary when summons are issued by ED.
We must first of all acknowledge that these officers at ED are one of the finest officers of the country. So they are very well prepared in terms of their jurisdiction, the territorial jurisdiction, and the scope. So one has to be very clear that from what perspective the questions would be asked. Importantly, if we see the question of summons, the summons would generally be issued under Section 37 of the FEMA or Section 50 of the PMLA Act. It is very interesting to note that PMLA provides that the person who has been summoned can be represented through the authorized representative. This is a very fine term which is specifically being used in section 50. So when these summons are being issued, and if there is a risk which a person feels, or if a person is not very confident to explain or express, that weapon of being represented through an authorized representative, which is mentioned in section 50, must be explored. It may often happen that the ED may not agree the representation through the authorized representative, and in those cases the court interference may be of relevance, because in lot of cases when summons are being issued under different statutes, courts have interfered and have allowed representation through the authorized representatives.